Do you believe that the executive should have no say in the appointment?
I don't support it. I started by saying that they have a vital interest in the...
Should they have a veto power?
No. See, they shouldn't have a veto power. The primacy of opinion must be that of the judiciary. The reason is, we know what is the caliber, the merit, and the suitability of the judges who are to be elevated. We have seen them right from the days they were lawyers. We have heard appeals against their judgments. We know how they think. We are best positioned to see which judge is meritorious. But those judges of the superior court, we are only talking of superior courts, because in the 70% of the judiciary, the public service commissions appoint them, which includes the government.
Yes.
We are only talking of High Court and Supreme Court. These courts, these judges have to take an oath of office. That oath of office says that I shall uphold the sovereignty and integrity of India, that I shall uphold the Constitution and the laws, and other things.
Yes.
It is important that a judge can do that as a judge. And on these aspects, it is often the executive's opinion which is vital. For instance, when the Intelligence Bureau reports to us, things like what are the activities of this judge. Now, you imagine a situation, a gross case, where one of the candidates is of the opinion that India should not be a sovereign entity like it is. There should be a separate state somewhere. Separate means outside India. The executive is in the best position to tell the court that this is not a suitable candidate, the collegium. So the executive's opinion is important. With or without the NJC, I have full respect for the judgment of the Supreme Court. I am saying that consultation with the executive can be made by the Chief Justice of India and the collegium. Their views taken, but I believe the primacy must remain with the Chief Justice or the collegium.
Okay, I think you've been pretty clear, categorical in that sense now about that. Consultation, but the final say must remain with the collegium is what you're telling me.
And consultation, I do not mean concurrence.
Okay, point taken. So we have very limited time left, but I'm going to ask you some more. Let's lighten the mood. The most difficult case in your career?
It's a case I didn't decide, but I'll tell you some. I mean, there was a laborer who was charged with rape and murder of a young girl.
Yes.
And and that chap had been convicted. When the appeal was pending, the investigating officer committed suicide, saying that I have been forced to implicate this chap. And he managed it successfully. The High Court agreed that his suicide note is true. And we were hearing an appeal. Obviously, he ought to have gone scot-free. This is Lalit, the expert in criminal law. But I took the view that we should not acquit him till we prosecute these prosecution witnesses who had lied through their teeth. And there was a difference of opinion between my colleague and me. He said, no, we'll just let him go. I said, no, we must prosecute him. Fortunately, unfortunately, the bench changed. And I couldn't decide that case, but I have never been so foxed in a case as in this one. Because the suicide note was not part of the trial record.
It's interesting you're saying that because your one judgment did create a lot of controversy, where you, not judgment, but an observation you made in court, where you suggested to a rape victim that she marry.
I didn't.
This is what was reported.
I'll tell you what happened.
That she marry her alleged rapist.
Frankly, I want to tell you what happened because I haven't got a chance to tell anyone what happened.
Please do.
The boy and the girl had a love affair. They were related to each other distantly. They had a love affair, and their parents on both sides objected because they were spending a lot of time together. So they told them, you get married. You can't carry on like this. They had an affair for 7, 8 years. And they signed an agreement that we'll marry. Now that chap came in appeal. He applied for bail. And that woman then said that I'll prosecute you for rape because we've been having sex and you haven't married me. So that his bail was rejected. He came by way of a bail application before the Supreme Court. I told him that what is this matter? You've been living together and there is this agreement on record which you have signed to solve this family dispute. Right. And are you going to get married or not? That is what I asked.
Okay.
And just a minute. And then I rejected his bail application because they said, no, we have not married, I haven't followed this agreement. I rejected his bail application, and these intelligent people in society wrote to me saying that you must review your orders. Means what? Grant him bail. Absurd thing.
Okay, this is the danger of obiter dicta.
Yeah.
Making headlines. But my final question is, there was a nice picture of you on a Harley Davidson. We haven't seen too many CJIs on a Harley Davidson. You're a Mobike fan. We didn't know it till then. Any regrets about posing there in...
I wasn't posing. Somebody got that Harley Davidson. I sat on it. And there was somebody who had nothing to do with anything who took a picture and sent it to her lawyer husband.
Right.
And that is how it went around. I didn't ride it. I only sat on it, though I would have liked to ride it, I will tell you that. It was COVID times, there are a lot of, you know the rest. But frankly, I became very popular with the younger crowd.
You did. And you've also become very popular among judges because during COVID times, you brought in online technology to encourage more and more people to appear before court. It's now hybrid. And I think it's made a huge difference to the courts. And that will be one of your many abiding legacies, Justice Bobde. But thank you so much.
Thank you.